Good morning, everyone. Welcome to our first webinar, a joint webinar between the Pension Solutions Group Limited and Coffin Mew solicitors. It's great to have everybody on the webinar. It's a joint webinar, as I say. My name is Duncan Parsons, CEO of the Pension Solutions Group and TPSG SIP Limited. I'm joined by Amanda Reid, partner at Coffin Mew, the particular specialism in commercial property purchase and investment in pension schemes. We're going to go through this short presentation, and we're going to invite questions at the end. But you can actually submit questions on the chat box at any time. There won't be a huge amount of time for questions at the end, but we will pick up any that we don't get through if there are those that we don't get through, and we will come back to you. We're going to give you some copy slides as well after the event. So the table of contents, we're just going to go through introductions to PSG for those of you who don't know, and welcome to any clients of ours who are already on the webinar. Thank you for joining. We're going to look at the world of commercial property very briefly, but only through the lens of why it's attractive generally in pension schemes. We're going to be looking at how it actually works as an investment in pension schemes, and I appreciate that there'll be people who will know how that works at various different levels. So we will try and be general. We won't get too technical, hopefully. Amanda's then going to take us through the legal requirements and considerations, because the solicitor, when dealing with property purchase for anyone, is obviously looking at risk and making sure that property is going to be a sound asset, if you like, to be acquired. But where there are trustees involved and there's pension tax relief involved, is arguably even more important. We're then going to look briefly at the benefits of the combination of the Pension Solutions Group and Coffin Mew and the long-standing relationship that we've had. I've already introduced myself, but just to say a little bit about the companies, we look after business owners and private clients. There's a lot of business owners who are interested in investing in commercial property. Some of our clients are high net worth, sophisticated investors, and they will have property portfolios of their own outside of the pension scheme. And there are sometimes some pension planning opportunities that arise for those types of clients. So we provide SaaS, small self-administered schemes within the Pension Solutions Group Limited, and we provide SIPs through PSG SIP Limited. PSG SIP Limited is also able to provide exempt property in a trust, which is a particularly specialist structure for commercial property and sometimes residential property. So I just want to mention that. We'll come into more detail on that in a moment. We have a dedicated property team. It is a specialism of ours, and it's been so since we started PSG. Within that team, which is headed up by Bernadette, we have administrators who are looking after all aspects of property. So there's an administration process to go through for compliant purchase in a pension scheme, which is separate to the legal conveyancing process that Amanda's going to talk about. So it's important to realise that there are pension scheme rules to obey, trustee duties to deliver as well. That's all done in this team, and it could be that we're buying property, selling property, leasing it, dealing with rent reviews, and of course always working with professional advisors and parties, obviously Coffin Mew in this case, solicitor. That could include, of course, surveyors and anyone else who would be involved in property investment, including lenders. Amanda, I introduced at the beginning. We've worked with Amanda for a number of years. Coffin Mew are looking after all sorts of different pension providers in the UK, and they are our solicitor of choice when it comes to property. I will let Amanda talk about what she does shortly in terms of her process, but there's some information on the slide there for you to have a look at. So the world of commercial property, we're not surveyors, we're not experts on commercial property, but what we can say is that there are a wide variety of potential classes of commercial property that can be acquired. There is a list here, it won't be exhaustive. But really it's effectively anything that isn't a residential property. And by that we mean anything that isn't something that you would class as a dwelling, or that has been a dwelling and has a use as a dwelling. And looking at the list, probably purchased quite a wide variety of that sort of subset, if you like, of commercial property in our schemes and our unit trust as well. It's a big bit of business, isn't it? Commercial property. It's an interesting asset class, very attractive to many investors. If it's not even a pension scheme they're using, maybe personal investment. We're not going to dwell too much on figures, but there's a little bit of information there on that. So how does it actually work in a pension scheme? It's long been an asset class that you can actually invest in a pension scheme subject to various rules. And what's particularly interesting about the UK schemes, so we're really focusing on SASs and SIPs here, is the ability to undertake transactions with connected parties. And that would include the member of a pension scheme, or where the scheme is an occupational scheme like a SAS, which has a sponsoring employer. In other words, perhaps the director's own company, which has set up the SAS. We can interact and buy and sell and lease to that connected company, whereas a sponsoring employer, that is. Now, clients who want to invest in property and acquire it from their connected party, so either from themselves or their company, have to do that at arm's length and need to do it under the advice of a qualified surveyor. You can't just set a purchase price or a sale price or even the value of a rental on a lease without that professional advice, and that is to protect the tax relief that HMRC has given to the pension scheme and to ensure that the transaction is commercial. But abiding by that generally means that you're abiding by what would happen in the open market. And as long as you obey those rules, there will be no issues with tax charges in the pension scheme for breaking those rules, and that's part of the role of the pension provider. The attractiveness of the property in the scheme, of course, is the fact that pension schemes don't pay income tax and they don't pay capital gains tax. And that means that if you're going to be receiving rental income to the pension scheme, you're going to be not paying tax, and that makes it very efficient. When the property is sold, whereas you would pay some sort of capital gains tax either through corporation tax or income tax, that won't also happen in the pension scheme. So property development, acquiring, if you like, planning permission and selling with planning permission are all things that could be done, provided it's all done at market rates. So what can go in? We talked about commercial property. We've said essentially that there is no way of doing residential property. It's defined as taxable property under the rules. And that means punitive tax charges if you invest in something you're not allowed to invest in. So residential property is essentially called taxable property by HMRC in their manual. It is possible to do residential property investment, and we do it, but we don't do it in a UK scheme. We can talk about that another time or touch on it later on. What we also have to be careful of is where a commercial property might be converted to residential, or in the other case, where something appears to be a commercial property but it isn't. It's a house or something that someone's using for that purpose, whether they have permission or change of use or not. And we have to be very careful about running the risk of acquiring something that will deliver us a tax charge. Some of that due diligence, of course, comes out through Amanda's work. How do we fund these properties? Well, pension transfers. So compliant recognised pension transfers. You can transfer pensions that already exist into your SAS or your SIP and consolidate. Obviously, we recommend advice is taken before doing that, and sometimes advice is mandatory before you can do that. Pension contributions, which are attractive in their own right because they should attract tax relief if the rules are obeyed. That's tax relief to the employer who may be paying a pension contribution, or to the individual themselves if it's a personal contribution. These would be the inputs, if you like, to the scheme that you could put towards buying property. Obviously, borrowing from banks or even from connected parties on commercial terms, subject to borrowing limits, will help purchase the property. But it's very important to note the limits on borrowing power in the pension scheme, because you can't exceed those limits. Otherwise, you end up with tax charges, and those limits are essentially 50% of the net value of the scheme. So the total assets of the scheme, half their value. Very important to look at the combined values of any borrowing and any existing funds from pension contributions and transfers in determining the real true purchase power of the scheme, because we have to factor in all the costs of doing so, professional fees, etc. We also need to bear in mind VAT, which may not be physically payable if the property is a transfer of a going concern, but if it is payable, all of these costs need to be factored in and met within the total purchase power of the scheme, even though we can reclaim VAT. Having registered the scheme for VAT, we can reclaim it after the event if it's payable. If you can't fund it all, then you can't do it. You can't borrow extra money to cover that shortfall if there is one. Where there is a shortfall, one of the attractive options that we've often used with clients is to co-own property with a connected party usually, because then the control is kept in the pension itself and that connected party. And that in itself may help to deal with a property where there's a bit of a shortfall somewhere. Coming on to this alternative structure, it's just worth mentioning this. We're going to focus on this as being something which will be done with a SAS rather than a SIP for regulatory reasons we won't actually go into today. It's just very expensive to hold what the FCA say are liquid assets in SIPs. But the Exempt Property Unit Trust is a specialist private investment fund that we can provide through PSG SIP Limited, TPSG, the regulated activity being carried out by PSG SIP Limited. By unitising property investment or any other investment for that matter, it provides us with quite a lot of flexibility in terms of moving that property around, which you may wish to do. That would mean no stamp duty, land tax, no legal fees, because we're not physically moving the asset, we're moving units in unit trust. And what would happen is the pension scheme would simply invest its resources into unit trust in exchange for units, and then unit trust would have its own investment strategy and memorandum, which is essentially the transaction the client wishes to carry out. The structure is very flexible. Investors in it need to be high net worth or sophisticated investors to obey certain regulatory rules, and that's simply because it's deemed to be a more sophisticated and potentially more risky structure. However, risk in itself is similar to the SAS and the SIP, because it is essentially usually the property that the clients already own or wish to own. That's not to talk down risk. Commercial levels of lending, by the way, are available in the put. They're not really levels that you can't really describe as commercial levels of lending in SASs and SIPs, because loan to value effectively in SASs and SIPs is about 20 to 30% loan to value. And we know what levels of loan to value are deemed commercial by banks is between 60 and 75%. So that's another attractive point about unit trust. It's not for everyone by definition, though. The EPUT doesn't deal with residential property. However, when it comes to a UK scheme, putting the property in the EPUT does not change the rules so far as residential property is concerned. It's just simply deemed indirect holdings by the SAS rather than direct holdings, and therefore we wouldn't permit residential property in an EPUT with a UK scheme. I've touched on the borrowing already, as been talking through the slide. One interesting additional thing to say is that whereas in a SAS or a SIP you may have difficulty with funding VAT, even though it's coming back into the scheme as a reclaim, that additional VAT can usually be borrowed on a short-term basis. Banks are usually prepared to do that on the basis that that VAT will come back over a period once HMRC are comfortable with the reclaim. And just to touch finally on one other aspect of some of the specialist work we do, the property work still being, of course, carried out by Amanda and her team, is the QNAP's EPUT solution, which is a qualifying scheme under the Finance Act. So HMRC recognises these qualifying non-UK pension schemes on the basis that they are qualifying schemes and meet the criteria. But what HMRC is not doing is providing any tax relief on the assets or the funds that are going as contributions to those schemes. As overseas schemes, they are still recognised, of course, though. And that means that an EPUT, an exempt property unit trust, can have investment from a QNAPs. And because there's no tax relief, the QNAPs is able to do more than a UK scheme would. The EPUT is, if you like, exempted then from what would normally be the ban against residential property. And there are significant planning opportunities here, pension planning opportunities with, of course, all the associated tax exemptions, which allow residential property. I'm going to hand over to Amanda at this point, so that she can talk through the legal requirements and considerations.
Good morning, everyone. So as mentioned by Duncan earlier, I'm a partner in the commercial property team at Coffin Mew. We work very closely with PSG, assisting with their legal property requirements. So the purpose of my part of the session this morning is to give you an overview of the legal process involved in putting a property into your pension scheme, what we do and why we do it. This process can take some time, but it's important for professional trustees to make sure they're taking proper legal advice. The purchase should be an investment. To make sure the trustees are complying with their professional requirements, they therefore need to be certain that they're paying the right money for the property. There are no unexpected matters that affect the property that might result in difficulties using it. There are no significant unexpected costs which might affect it, and that the property can be readily sold in future or can be mortgaged if needed. The legal due diligence process is designed to check if there are any issues that might affect the property and to try and resolve those in a way that protects the investment value. So, what do we do? Well, firstly, we'll review the land registry title and any leases which the seller should provide to us. We will be looking for what rights do other people have over the property. This can include all sorts of things, but the main examples are rights of access, rights of passage of cables or pipes over the property, and various other matters. Will those cause any issues for the proposed use of the property? We'll also be checking that the property itself has all the necessary rights for it to be used. Is there all necessary access? Does it have all necessary services? Is there relevant parking? Can the property be maintained or similar? We'll then be looking at any covenants which might affect the title. Will there be restrictions on how it can be used? Will the property owners be required to pay out any monies for repairs, maintenance, or otherwise? And finally, we'll be checking if any consents of other parties are required to buy the property or to grant leases to use it. This could be adjoining owner consents, management company consents, or lender consents. In particular, these can delay matters as we're relying on third parties responding to us, so this can take some time. I have a little plan on my next slide. This highlights some of the issues we might be looking for. The property being purchased here is coloured red. The property needs rights to park on the land coloured green. We need to check that it actually has this right or the parking may not be capable of being used. It also needs a right of access over the land coloured purple to reach the car parking. If these rights are not available, the value of the property may be affected, as it will reduce who might be willing to buy the property. We might also need rights to pass service media from Church Road over adjoining property, so we'll check for this. In this particular example, we'd also be checking there are rights of access to the front of the property. You'll see there's a small uncoloured gap there. If this land is owned by somebody else and they can prevent access, this could be a big problem. A property that does not have the required rights may be worth significantly less, or if it cannot be accessed at all, could be worth nothing. As part of our due diligence process, we'll also conduct a number of searches. These can take time to obtain, which can be frustrating, but we are relying on the local authority, water company, and other third parties to provide responses to those searches. We might then need to seek further documents from those authorities, depending on what the search results reveal. Our usual searches would be an index map search, checking that there are no gaps in the title or other titles that affect the property, for example, leases or rent charges that we didn't need that we didn't know about and need to review. A chancel search to see if the property owners are required to contribute to costs of repair of a local church chancel. This can be expensive, and banks usually insist on insurance. A drainage and water search to check if there is a main supply or a private supply. If there is a private supply, there could be additional costs for repair and maintenance, and this could be expensive. We need to make sure the property has all necessary services. We will usually carry out an environmental search. There are likely environmental issues that can cost significant money. Cleanup costs can be significant, so it's important to establish any possible problems here. We'll then carry out probably the most important search, the local search. It reveals anything the local authority know about the property, so it covers lots of different matters. It can bring to our attention enforcement notices that need to be complied with, common land where other people might have rights over the property, details of exactly where the public highway is so we can check we have the access we need. Are any works expected in the area of the property, for example, roads or railways? Is the property listed or in a conservation area, meaning extra consents and costs might arise for any alterations of the property? Are there any planning agreements or other notices that might require action to be taken at the property in future or cost to be incurred? One of the key things our local search reveals is planning details. This is very key for commercial property. Can the property be used as intended? If the property does not have the right planning consents, the local planning authority can prevent it being used, which can of course affect value. For example, if the property was residential, but the seller has been using it as offices for a short period without planning, the local authority could insist on the use being returned to residential. New planning consents might need to be obtained, which can be costly. If the local authority are not willing to grant new consents, the property simply cannot be used as offices and remains residential, which may cause issues, as mentioned by Duncan earlier. We'll also be checking the position regarding any alterations at the property. Alterations often require planning and building regulations consents. Were all relevant consents obtained for any alterations? If not, the local authority may be able to ask for those to be removed or altered, which can have cost implications, as the responsibility will pass to the buyer. And finally, are there any conditions to planning consents which might cause any issues or restrict use? For example, limited opening times or restrictions on who can occupy the property. This again can affect value. Have conditions that need to be signed off by the local authority before the property can be occupied being complied with. If not, this could prevent use. The final stage of our due diligence process is making sure we raise standard property inquiries of the seller. It's a very long form that we send out, but it should make sure the seller tells us everything they know about the property. It includes details about any monies that need to be paid out for the property, for example, service charges for repairs and maintenance of common areas, utilities, and other items. Providing confirmation regarding any statutory requirements, including energy performance certificates, asbestos, and fire surveys. Making sure the seller has notified us of any known breaches of any obligations that affect the property that we might need to know about going forwards. Confirming the VAT status of the property, so any necessary arrangements can be made to pay and recover VAT, as mentioned by Duncan. And finally, providing further details about the day-to-day use of the property, so we can make sure there are no other issues which might affect value or result in monies needing to be paid out that might not have been known about otherwise. So when you buy a property, the general rule is let the buyer beware. The buyer is to make proper checks to ensure they are happy with it. If they do not and anything affects the property, the fact the buyer did not know about them does not stop them still affecting the property. The legal process is to make sure the property is a good investment and any issues are known to the trustees before purchase. The legal review is all about, can we use the property as needed without significant unexpected costs? And about value. Is the property worth what is being paid for it, and can it be readily sold? If not, it is not a good investment. The professional trustees need to make sure they are fully aware of anything that might affect the property. The legal due diligence process is there to make sure they and their investors have a full understanding of what affects the property. Issues do sometimes arise. Our aim is to work very closely with PSG to ensure the property can still be bought, but any risks identified from the due diligence process are minimised or resolved before purchase. to protect that investment value.
Thanks, Amanda, for taking us through that. So we've been working with Coffin Mew for a long time, and there's always something else that might come up you haven't come across before when you're buying a property. Hopefully nothing arises, but that is the challenge sometimes. And where something does arise, it needs to be managed. And I think the main thing to say is that the proactivity and the search for a problem or a solution is in the forefront of both our minds. It is definitely the case that certain issues have arisen, even with properties owned by clients that they're selling to us, which they were not aware of. Not through their fault, just things that are historical. Issues with services, for example. And there's been more than one occasion where Amanda and the team have discovered something, and then we put our minds together about how to deal with and resolve the issue so that it actually becomes a sale that can go through. And in the case of a client who wants to buy that in their pension scheme, then of course they're now, having resolved those issues, holding a property in the pension scheme as they wish to do. This, of course, has the effect of de-risking the investment and making sure that we don't have problems in the future when we come to sell, as Amanda was explaining. And that really wraps up the presentation side of this. I just want to have a look and see if we've had any questions. We have got a little bit of time left to cover any questions.
Yeah, I don't think we've got any.
Okay, so we don't have any questions. That doesn't mean, though, that people can't ask questions, and I think there'll be a means, we'll be in touch if that's okay with you, to give you a copy of the slides and to invite any questions. If you want to ask any questions now, you can, by the way, before we actually finish. We're aiming to finish at 11:30. In case no one does, sorry, we have a question. Yeah, so this is a common one, and there's been a couple of issues that have cropped up with some historical cases. I won't go into them, but the French Alps and the Swiss Alps have been very popular with holiday accommodation. There's a very narrow way of actually doing that kind of thing. The answer is that actually no, holiday lets as a general thing don't work. They are very often self-catering by nature, and they'll have kitchens and things and all the things you'd expect to have to enable you to actually live in them, even if the use wasn't there, even if they've got some sort of restriction. Although that's definitely residential property. I know that the activity, a bit like HMOs, high occupancy buildings, that the activity is deemed commercial, probably paying commercial levels of tax or whatever on them, potentially, but they are still residential properties. Yes, and I think the question goes on, what about if we bought a residential house and then turned it into a holiday? I think there is no difference, I'm afraid, on that. But having said that, this is all to do with the UK tax relief which is given, and the government's policy, which is that UK tax relief funds should not be used to buy residential property, new property or property from your pension member. However, the QNUPS combination, which would require the exempt property unit trust, as I said earlier, won't be relieved in the UK. It's recognised in the UK, but won't be tax relieved, and therefore these taxable property, residential property rules don't apply. The QNUPS itself, I've had a question from one of my clients, Paul, thank you for that. The QNUPS structure is an offshore pension scheme. Offshore pension schemes don't generally want to buy property directly because they'll be subject to tax, and they don't like holding property directly in their trust structures or their pension scheme structures. But they will be able to use something like an exempt property unit trust or a limited company. I will say the exempt property unit trust carries the tax exemptions, the limited company doesn't, to hold property. So the QNUPS itself wouldn't be the borrower. In that case, the exempt property unit trust would be the borrower and the property owner. And therefore, because of that, and because the unit trust is an English unit trust, we're not looking at an offshore arrangement trying to borrow money from a UK bank, which used to work, but banks don't want to lend to people in the UK sometimes, never mind people offshore. So the answer is the QNUPS structure with EPUT actually owning and borrowing would work. You wouldn't have a situation where the QNUPS itself was going to borrow money. And that, I'll just say that obviously commercial terms are not subject to UK borrowing rules. And that's the last question. We are now at 11:30. So I just want to thank everybody for joining us, and thank you on my behalf, PSG's behalf, Amanda, and Coffin Mew's behalf. And we hope to talk to you again sometime about another topic. Thank you very much, and good morning.